The Georgia Satellites once famously told us, "Don't hand me no lines and keep your hands to yourself." But what happens when you don't keep your hands to yourself? Hi, I'm Jack Razumich with Razumich & Associates, and today we're going to take a brief look at Indiana's battery laws. Battery is a criminal offense in the state of Indiana that's defined as knowingly or intentionally touching a person in a rude, insolent, or angry manner. Like most offenses, battery is initially charged as a misdemeanor offense but escalates quickly depending on the circumstances. For example, battery resulting in bodily injury gets charged as a Class A Misdemeanor, battery resulting in moderate bodily injury is a Level 6 felony, and battery resulting in serious bodily injury is a Level 5 felony. Certain circumstances, the alleged victim can also affect the level of the charge. Domestic battery in the presence of a child is charged as a felony offense, as are all batteries on public safety officers or batteries on pregnant women. The most serious types of battery offenses, such as batteries involving deadly weapons or batteries that carry a substantial risk of death, are major felony offenses that can carry significant prison terms. A key issue with most battery offenses is the fact that injury isn't actually required for the basic offense, and the definition of injury is incredibly broad in Indiana. The legal definition for injury in Indiana is any impairment to physical condition, including physical pain. This means that any pain, even the temporary pain for being slapped with an open hand that leaves nothing other than a temporary redness, can result in serious criminal charges. The law makes no distinction between that type of pain or an injury that results in more serious bruises or cuts. There are three major ways that you defend yourself against a battery offense in Indiana. The first is to argue that there was no battery. This is what's referred to as an actual innocence claim. This type of defense is raised when there are no physical markings to show that a battery happened and is most common in what's known as a he said, she said situation. The second way to defend yourself is to agree that the battery happened, but argue that the defendant was not the person responsible for the injury. This type of situation comes up when it's clear that an injury happened, such as when there are visible scratches or bruising, but the defendant argues that they didn't actually cause the injury. Some domestic cases involve this type of defense, such as when the argument is made that the alleged victim scratched themselves or that the injuries otherwise existed before the alleged criminal act. The third way to defend yourself against a battery charge is to agree that the battery happened, agree that the defendant was responsible for the injury, but argue that the defendant had a legally justifiable reason for committing the battery. This is what's referred to as a self-defense claim. Self-defense claims are very fact-specific, and while all good attorneys do investigate battery charges for the possibility of any self-defense arguments, not every battery offense is going to be able to use a self-defense argument. Properly defending a person against a battery charge is more difficult than people think. The first thing that a defense attorney investigates is whether there were any witnesses to the alleged battery. The longer it takes to locate those witnesses, the more difficult it is to guarantee that a story that might prove a person's innocence is properly preserved. Human memory does tend to fade over time, and failing to interview those witnesses quickly can have dire consequences for your freedom. Medical records also may need to be reviewed, as sometimes a person will claim that their injuries are more severe than is actually true. You should never build your defense around the idea that somebody's not going to show up to court to testify. Not only are there consequences for witnesses who ignore orders to appear and testify, but if you build your defense around the idea that a person who is already so angry at you that they contacted the police and accused you of beating them, that's the fastest path to finding yourself inside of a prison cell. The consequences of being convicted of a battery offense can be significant. In addition to the normal consequences of having a criminal conviction, battery offenses can affect your ability to see your own children, as this type of an offense is regularly used to restrict parenting time and can sometimes outright change a child's custody between parents. Depending on the nature of the battery conviction, you may also be prohibited from owning or possessing a firearm, and certain professional licenses can be affected by this type of a conviction. Choosing the correct attorney to defend your freedom in a battery case is one of the most important decisions that you'll ever need to make. Here at Razumich & Associates, we've defended people accused of battery all across Indiana. We fought for their freedom, and we can fight for yours too. If you or someone you love was accused of a battery offense, call us today at 317-983-5600. 5333 to schedule your free case evaluation. Case evaluations are always free and always will be. The only thing you're investing is your time in having your questions answered, and you'll be glad that you did. If you like that video, please remember to like and subscribe. If you really like it, please consider sharing it on the social media platform of your choice. Here at Razumich & Associates, we are lawyers ready to fight. The more eyes that we're in front of, the more people we can fight for. The more people we can fight for, the freer we all become. If you have a question or a comment or a topic that you'd like for me to address in a future video, please consider dropping that in the comment section down below. Thanks for watching, and I'll see you next time.